Peter, good afternoon. Nice to see you again.
Nice to see you, Trevor.
Unfortunately, I'm speaking to you from my motor vehicle. It's a nice car, so it's not that unfortunate. But load shedding required me to use the Wi-Fi in my car. So that's why my surroundings look a little bit different. Anyway, nice to see you. You look relaxed and full of beans.
Absolutely. It's been too long.
It has indeed, yeah. So we'll make up for it. We'll do podcasts at night as well.
I like that.
It reminds me of the story of Spike Milligan. He said he arrived late when he was called up at the army, and he said, "Don't worry, I'll make up for it. I'll fight nights as well."
Oh dear. Brilliant.
Right, so who's going to kick off? Our topic is fiscal default judgment, I suppose one could call it. Do you want to deal with the facts of the most recent case? Well, I must admit I saw another one this morning, but
there've been a few.
Yeah,
been a few. The one I'm talking about is it's called the Taxpayer case. It was heard late last year, and then it was released. The judgment was released early this year, and it involved a default judgment, as you say, against SARS. I think maybe just the background is, to understand the rules.
Is that the judgment of Judge Clutie?
Yes, exactly. And maybe the context, just talking about the rules of court and how they sort of fit into the process. And the rules of court obviously promulgated in terms of Section 103 of the Tax Administration Act. And they basically prescribe the processes and procedures in relation to tax disputes, including timing for various filings and pleadings, etc. And I think the relevant rule here, the most important rule here, is Rule 56, that allows one of the parties to apply for an order, basically compelling the other party to comply with a timeline in circumstances where it hasn't complied with the timeline. And if the other party doesn't do what it's supposed to do within 15 days, then the aggrieved party can apply for a final order. And it was that Rule 56 that is relevant in this case. And basically what happened, Trevor, is that, as you know, SARS raised additional assessments just as we went into hard lockdown. And the taxpayer was aggrieved by the additional assessments, and it asked SARS for some reasons, which you're allowed to do. So it requested reasons from SARS within the specified time frame. And then SARS needs to give those reasons within 45 days of the request, and it failed to do so. So strike one against SARS. In fact, what SARS did is it unilaterally gave itself an extension outside of the 45-day period, which it's not permitted to do. And it then provided its reasons just before the end of that unilateral extension. And then the taxpayer then delivered its notice of objection, as it needed to do, within 30 days. And SARS then obviously needs to decide what to do in respect of the objection, whether to allow it or disallow it. And again, strike two, SARS missed that deadline, and the taxpayer put it to terms in terms of the Rule 56, delivered a Rule 56 notice. And SARS then partially disallowed the objection within the 15 days. So it complied with the 15-day period prescribed by Rule 56. And the taxpayer then delivered its notice of appeal, again on time. And the next step for SARS is to deliver its Rule 31 statement within 45 days. And again, that didn't happen. So the time period came and went, and SARS didn't deliver its Rule 31 statement. And the taxpayer, again, strike three, delivered a Rule 56 notice compelling SARS to remedy its default within 15 days. And SARS provided some quite generic reasons for the delay and asked for an extension of 2 months. The taxpayer gave it an extension of 1 month. And despite that extension, SARS didn't deliver its Rule 31 statement within the extended period. And the taxpayer said no further delays, and it launched its application for a final order in terms of Rule 56. So quite interesting, Trevor, that, just I think on every every time SARS needed to respond, it was late. And I think that obviously doesn't play well with a court and with a judge. So I think those are kind of the basic facts there.
Yeah. One aspect of the facts that struck me, and I suppose one shouldn't make too much of this, but something can be made of it. Judge Clutie, if I'm not mistaken, said that one of the excuses provided by the SARS representative was in fact untrue.
Mm.
They said they'd briefed counsel, and in the answering affidavit, once they'd locked horns, a different version was given. That doesn't go down well. Not to the court, and certainly not to a reader either.
That's exactly right.
Yeah.
They said that the relevant assessor had briefed counsel, and in fact the assessor had briefed the state attorney to brief counsel.
Yeah.
And the judge said in terms that the statements made by SARS were untrue.
Yeah.
So as you say, SARS is late with every filing, and it's found by a court, by the judge, to be untrue in terms of its statements, and that obviously is not creating a good atmosphere for its case.
So then, speaking from memory, the court then discussed the whole thing. They did have a look at the merits, and they decided that the taxpayer had a strong enough case, because in a situation like this, one always has to address the merits.
Mm.
And I do have Rule 56 with me, and Rule 56.2 says the tax court may, on hearing the application, A, in the absence of good cause shown by the defaulting party for the default in issue, make an order under section 129.2. That's section 129.2 of the Tax Administration Act, which are all those orders that the tax court is normally empowered to make, when hearing an appeal.
Mm-hmm.
So it's incumbent, whichever part, and this can work both ways, whichever party is at fault, it's incumbent on that party to show good cause. And clearly in this case, SARS did not show good cause. Then that's the one thing. Or B, make an order compelling the defaulting party to comply with the relevant requirement within such time as the court considers appropriate. And if the defaulting party fails to abide by the court's order by the due date, make the order in terms of blah, blah, blah. But both of those are introduced by the word may. So there seems to be a discretion involved in every case. The judge's hands are not entirely tied, as I've discovered in one instance myself.
I think that's right. And the courts sort of look at two things, which I think are important. First of all, the issue of prejudice. So yes, SARS is late, and they've been consistently late, and all their filings have not been on time. But what's the prejudice to the taxpayer? And I think the taxpayer was quite interesting, because they raised a lot of arguments around prejudice, and they're tied into suspension of payment. And the taxpayer said, it's very important to me that I'm shown as a compliant taxpayer on your e-filing system. And originally the taxpayer was shown as compliant. And then after the disallowance of its objection, it was shown as non-compliant. And it struggled to get back to the compliant status. And it says that that's fundamental to its business and its business operations. And that was severely prejudicial to it, that it was shown as non-compliant through this whole process. And the longer this whole thing drags out, the longer it's likely to be shown as non-compliant. And that was sort of fundamental to its business operations. I think that's quite an important factual point there, Trevor, that you can actually show sufficient prejudice. Otherwise, I'm guessing a judge might just say, you know what, SARS, you've been late. That's very naughty, slap on the wrist, and here's another 10, 15 days or whatever it is. So I think the facts are quite helpful to the taxpayer.
Yeah. And then the other thing that the court considered was the merits of the case. Now, obviously, it's not a full hearing, so you can't satisfy the court on the merits the way you would at a full appeal with evidence and discovery and all of that. this is at an initial stage. So one's dealing with the prima facie case that the parties are in, and one has to satisfy the court that there's a reasonable, that the party seeking the relief has reasonable prospects of success, which clear it was held in this case was the case.
And I found that interesting because the facts basically around the merits are quite not really dealt with in too much detail in the judgment, but basically the case involved a deduction of insurance premiums paid by the taxpayer to R&B Structured Insurance Limited. And there was a whole lot of statements around how complicated this issue is. And from SARS's side, they said it's very complicated and it raises all sorts of novel issues around deductibility. And that's why it had to brief counsel, and that's why it all took so long. But the judge was persuaded, as you say, Trevor, quite quickly and without going into the detail of it, that there were merits. So obviously there's a completely different test here in Rule 56 around merits than there would be if it had gone to the tax court. So it was a very sort of short circumvention, if you like, of the whole tax court process. But obviously fundamental that you can show that you have got merits. Otherwise, again, the court will just give a different judgment, I would guess, under Rule 56 and say, I'm not going to grant you a final order getting rid of the additional assessments. I'll just, for example, give SARS a bit more time to come and argue their case. So I think the merits for me was very interesting, how they took a very complicated issue, as SARS said it was complicated, so did the taxpayer, lots of novel issues, and the judge disposed of it, and the final order was granted. So, and that would have been no witnesses, etc. Trevor.
Yeah, but my recollection is what she said in that regard is that I think she just didn't believe what SARS said about it being complicated and taking time, because they must have considered it when the assessment was issued, when the objection was disallowed, and so they weren't coming at it for the first time. So that just didn't wash.
I like that point, because I said, the reason it's taken us so long to come back with our Rule 31 statement are because it's so complex, etc. And the judge said, although it really resonated with me, he said, hang on, you've disallowed the objections. How did you disallow the objections if you didn't apply your mind properly to it? You can't come and say it's complicated now, because it was also complicated when you looked at the additional assessments and the objection to them, and when you partially disallowed those. Yeah. So clearly you've applied your mind to these complex issues, and you thought about it. So
to which they said we have to apply our minds afresh at each stage. And,
yes.
But that's not the full picture.
That's right. And the court then again sort of dismissed that point. I think I said, you don't have to apply your mind fresh at each. It's the same issue. You've applied your mind already. You've made a decision, and need to move on. I thought that was very clear, and it certainly seemed correct to me.
Yeah.
And
sorry.
Carry on.
Can I mention one aspect where I think Judge Clutie missed a trick? A fairly minor point, I suppose, but it's nevertheless worth noting. Section 50. Rule 50, which is the start of Part F of the tax court rules, and it provides various things in relation to the rules. And Rule 55 says the following: the tax court hearing an application under this part, which is what Rule 56 is, may A, make an order as referred to in this part, together with any other order it deems fit, including an order as to costs. If you remember, at the end of the judgment, Judge Clutie referred to Section 131A and B of the Tax Administration Act, which essentially provides that in a tax appeal, where it's the full trial, costs are only awarded where either party's grounds are unreasonable, or held to be unreasonable, and it's on the request of either party. This seems much wider, and there's a judgment of Judge Rogers, as he still is. I think he's waiting to hear whether he's going to become a constitutional court judge, is what I'm alluding to, where he said that in his in his, it was an interlocutory application in relation to the case that later became DataCore, not DataCore, DigiCore. He said that the practice in regard to these applications is that the costs will usually follow the result, unless it would be unjust for that to be the case. So Judge Clutie awarded costs in favor of the taxpayer, if I remember correctly, but they had asked in the heads of argument for punitive costs on an attorney and client scale, and she didn't do that. I would have thought she might have been justified in doing that if she'd had a look at this rule and also taken into account the fact that something that was said was in fact she found to be untrue. That might have warranted costs on a punitive scale.
Exactly. Costs were ultimately awarded on party and party and not attorney-client, as you say.
Yeah.
It's interesting also that SARS brought a counter application. They asked for condemnation, and the determination of a further period for delivery of their Rule 31 statement, which obviously they're entitled to do, and that was opposed as well. But I thought quite cheeky to bring a counter application where all the sort of facts are against you, and obviously didn't succeed on that. But interesting that the other party can bring a counter application and can ask for condemnation. And I suppose again.
Yeah, if they hadn't brought an application for condemnation, then the applicant would say, look, they haven't even applied. Not only couldn't they get the Rule 31 statement out, but they haven't even applied for condemnation. So I suppose they more or less had to.
Yeah, and the court held that the relevant standard for condemnation is the interest of justice. And so the court then went to Section 33 of the Constitution, talking about the entrenchment of the right of everyone to administrative action that is lawful, reasonable, and procedurally fair. And that led them on to the issue of prejudice to the taxpayer. So it was interesting how they got there. Section 33 of the Constitution, giving you the rights to fair administrative action, and then leading through that to the issue of prejudice to the taxpayer. And then, as we said, going into suspension of payment, etc.
I must say, I really enjoyed reading that. It's nice to have the Constitution brought home in practical reality.
Yeah.
So often there are these lofty ideas and they just get ignored in practice. I'm confining those remarks to tax.
Yeah. And it's interesting as well how the suspension of payment always rears its head. We've spoken about this before. It's such an important part of these tax disputes that you get your suspension of payment application in under Section 164. And in this case, that was done. But at some point, your suspension of payment application is re-looked at by SARS. And in this case, they granted it, and then they re-looked at it after they disallowed the assessment. And then they said, they basically revoked their suspension of payment that they granted the taxpayer. And that led to this prejudice argument, which ultimately led to the award against them, this final order against SARS. So suspension of payment sort of pops up everywhere.
So there's a silver lining to every dark cloud.
I find it quite interesting.
I wonder, when I read that, I've been involved in a case where one taxpayer repeatedly was firstly extension of payment was not granted, but as you know, if it hadn't been refused, so you are de facto protected during that period.
Exactly.
And then suddenly money was taken out of this person's account. An issuer actually filed papers in court, and then SARS backed down, agreed to pay costs and all that sort of thing, and then granted a suspension. And then something else happened, and again, money was taken out of the person's account. No notice, nothing. And, I suspect that there's something that triggers the computer. I think it's done by electronically, because it would just be too inconsistent for someone to actually sit down and say, okay, we're just going to do this now. I think they need to check their computer systems.
100%.
Provides the taxpayer with prejudice.
It goes through e-filing. Yeah. And the system is not perfect, and it's an automated electronic kind of system, no warm body sort of applying their minds to stuff. And I think that causes taxpayers prejudice, but ultimately SARS as well, if the matter goes to court.
Yeah.
And,
Can I mention another case that I was in?
Mm.
Unless I don't know if you
No,
don't want
sure.
to move on. I did a case which ended up in front of our co-editor of the Taxpayer, the now retired Judge Davis. But there was a Clutie judgment before that which granted default judgment. I think it was the first one, and that was the same taxpayer. That was granted in respect of the 2005 to 2012 years. And I mean, this taxpayer is quite well known because it's been to the Supreme Court of Appeal and all of that. The taxpayer had constructed a prison, and it had a 25-year contract. So there was nothing new. It was just the next year of assessment and the next year of assessment, but the goalposts kept being changed. And in respect of the subsequent period, again, SARS didn't provide their well, there was the facts giving rise to the Clutie judgment, and Clutie granted default judgment. And again, the taxpayer had given 45-day extensions, another one, and yet another one, and still SARS did nothing. So that came to an end. Then in respect of subsequent years, same thing again. And another Rule 56 application was brought, and it went to the tax court, and the judge was Judge Nuku in Cape Town. And he did something which took everybody by surprise. He found against the taxpayer on a basis that SARS had never relied on. Basically, the taxpayer was late in submitting its objection. And you know, I don't want to go too much into the background, but there was an explanation for it, which is why it wasn't an issue between the parties. So the taxpayer then appealed against that decision to a full bench. The full bench set aside the decision of Judge Nuku and referred it back to the tax court in terms where, and I was involved in the case, so maybe I'm a bit subjective, but in terms which certainly suggested to me, again, it was during the time of COVID, but SARS was given a time within which to file its pleading, or we could approach the tax court again on the same papers. And SARS didn't file it. It went way beyond, you know, even with various extensions due to COVID. And the matter then came before Judge Davis. And he wrote a judgment. And if you read like 80% of the judgment, it looks like it's very much in our favor. And he awarded costs in our favor on an attorney and client scale, but he didn't grant the default judgment, which seems a bit of a contradiction. And it seems that the basis for that was that there was a lot of money involved, and the merits hadn't been adequately assessed. But of course, the merits were exactly the same as they had been in the Clutie judgment the first time around. You know, and my feeling after that case was, you know, this is a default judgment. Yes, you do have to show that the taxpayer is not just being frivolous and all of that. So you have to show a prima facie case, but it's not, you know, it seemed to me to be, with respect, wrong of the judge to say, you have all my sympathy. He referred to the archipelago of SARS's various misdemeanors. I think he should have said the Gulag archipelago, because it was prison as well. But anyway, and yet he felt we need a hearing on the merits. But the point is that this rule is there to grant default judgment. It is a default judgment. It's just so that the taxpayer can be exposed to serious penalty just for being one day late with something. And as I said earlier, that this thing can work both ways.
Yeah.
It could be SARS applying for default judgment against the taxpayer.
Exactly.
But so it's sort of agnostic in that sense. But where there's a clear and flagrant misdemeanors on the part of SARS warranting a punitive costs award, surely you should get default judgment as well. Anyway, so the merits are important, and one must always make submissions on the merits.
I think that's a really important point for all the listeners, because we often get that in tax dispute matters, because SARS are often a little bit late, and the day that they haven't filed, if they're supposed to file on a Monday, on the Tuesday, the client will phone up and say, let's go for default judgment. And you have to say, hang on, guys, it's not that simple. They're a little bit late. There's no sort of silver bullet around that. There's lots of leniency that will be granted to them. And Rule 56, as you say, in the first instance, is not a final order. In the first instance, you basically putting the other party in default and saying you've got 15 days to remedy your default. And 15 business days, that's quite a long time. You can do a lot in 15 days. So this whole concept of, if SARS are one day late, then it's game over and we're going to win. Forget about it. You put SARS to notice. They've got 15 business days to remedy their default. But if they don't do that, then you apply for the final order. And as you said, Trevor, that final order is not a slam dunk. You have to show prejudice and you have to show merits, and you have to succeed in both of those. And that's where this judgment that we first talked about was so interesting, that the taxpayer succeeded in showing both prejudice and merits. And I think that's quite unusual. And just to make that point, I think judges will typically want not to grant default judgment against either party in these circumstances. And I think what helped the taxpayer in that case was the fact that the judge had found that SARS had been untruthful in certain respects and had been late in every single filing. And I think that sort of played into the default judgment. But just the warning that, just because SARS are a little bit late doesn't mean that your matter is going to go away.
Oh. And I think as a generalization, the more rope you give SARS, to put it metaphorically, but grant them extensions initially, and so you've been more than reasonable, then apply for default judgment. Then your chances are much better.
I think that this case that we talked about was very well managed by the taxpayer and the taxpayer's legal team, because as you said, they granted SARS an extension for the Rule 31 statement. SARS asked for 2 months, they granted them 1 month. Very reasonable. And SARS didn't comply with that extended period, and that led to the Rule 56, the second Rule 56 application that led to the final order. So it was a whole lot of confluence of circumstances and facts that sort of played in the taxpayer's favor in this case, but ended up in a successful order for them. And I think, Trevor, we've talked about this before, and I think Judge Sutherland said it best in the ABSA case. He said, there must be ways to avoid the long and protracted slog to the tax court. And what we're talking about is another way to avoid that. If you've got, or if all the stars align for you. So you can go review, you can go declarator, and if SARS are in default, you can go Rule 56. So Rule 56 is another thing in the sort of armory of the taxpayer, although as you say, it could be in the armory of SARS as well. They can also apply for default. It goes completely both ways. But it avoids the long slog to the tax court.
Yeah, and there's an old judgment of again Judge Rogers, where he made the point in that particular case both parties were at fault. There was a wait for a decision which took about 3 years, and so everything was allowed to drift. And he said that SARS should lead the way, but taxpayers also must take the initiative, and the remedy of the party if the other one is not doing what they ought to do is to bring one of these applications. So it's not, one's following the admonitions of a judge when one brings an application like this. It's not just that one doesn't just do it for the hell of it.
Just keeping the other party honest in terms of the timelines that are prescribed in terms of the rules of court, and which I think are fairly adequate. And they're also often extensions that are granted within those rules. And if there aren't, you can apply for an extension and the other party can either grant it or not grant it. And if they don't grant it, you can go to court and apply for an order from court granting you the extension. So the time periods, I think, are more than fair and sort of more than adequately dealt with. It's Rule 4 deals generally with extensions, and generally says you can get an extension before the end of the time period if you agree it between the parties. And as I say, if you don't agree it between the parties, you can approach the court to give you that extension. So there's certainly enough time, Trevor. And often the parties are fairly generous with each other, because you all know what it's like. And, you know, if you've got a whole lot of stuff you need to get hold of, you know.
Yeah, and you know, not to get too sanctimonious or lofty about it, when one enforces one's rights, you're actually enforcing your constitutional rights, and maybe in that way providing a service to the wider community, because SARS should be kept on its toes in the same way that taxpayers ought to be kept on their toes.
Absolutely. Absolutely.
Yeah.
Absolutely. So I thought very interesting cases, these. And as you say, you know, it's something that the taxpayers must be aware of. They mustn't read too much into this judgment and think, well, this is a great way to get out of my additional assessment, but it's something you need to know about and to apply in the right circumstances. So I thought very interesting.
Yeah. No doubt there'll be something else interesting for us to tackle soon.
Absolutely.
There's an interesting judgment on treaty residence in terms of the South African-UK double tax agreement. I don't know if you've read it. Perhaps we can discuss it
next time.
Yeah.
That sounds like a good juicy one for our next podcast, which will be coming up shortly, Trevor. Now we're back in the swing of things. So look forward to that one.
Okay, hopefully I won't have load shedding next time, and we can do it with a bit of light on the side.
Awesome. Thanks, Trevor. Nice chatting.
Nice to chat to you. Yeah.
Cheers.
Bye.